Hello and welcome to this podcast on the legal system of England and Wales with Ryan Murphy. Today, I wanted to talk to you about legislating at times of crisis and for emergencies. This is a technique of legislating that's used by governments to react to unexpected disasters, unexpected medical emergencies, terrorist attacks, nuclear disasters. Not unique to the legal system of England and Wales. Most developed legal systems have a recognition that sometimes things need to be done slightly differently in reaction to particular tragedies or particular circumstances. And I'm going to talk to you about the recent coronavirus pandemic. And so if you or your family have been affected by this pandemic, then it may be that you don't wish to continue listening to this recording. But it is an important example of how legal systems react to emergency situations. It has a personal poignancy at the moment because I'm actually recording this during the UK's lockdown, so a time where there are significant restrictions on individual freedoms and liberties as a way of dealing with and restricting the spread of the virus. So let's begin with a consideration of perhaps why do we sometimes need emergency legislation. So I've pointed out some of the times already in the brief introduction when we may need emergency legislation. It could be at times of civil unrest. It could be during a natural disaster, or at the moment, as the point of recording, it could be in reaction to a medical public health crisis or threat. So the emergency legislation tends to have typical features or is passed in a typical way. So normally what happens is you have a transfer of powers to the executive, to the government, and to its agents and agencies to make further legislation, to make secondary legislation, or to take certain decisions without recourse to the normal decision-making processes. So without recourse to Parliament, for example, or without following the normal parliamentary processes. That normally such legislation is fast-tracked through the legislative process. So emergency legislation often is passed within a matter of days. It normally is time limited. So the legislation itself would normally have a self-limit to it. The legislation will expire. The legislation will cease to have effect after a certain period if it's not renewed by some agreed process. That within the legal system of England and Wales, there will be parliamentary oversight. There will be some form of check on the powers that are contained within emergency legislation, but that oversight is often fairly limited. So there are some inherent dangers of using emergency legislation. So those are some of the dangers that are present in regular secondary legislation: lack of oversight, concentration of power in an already strong executive, the transfer of real significant powers to ministers. All of those dangers are present, but they're enhanced when you have fast-track legislation and you come up with less rigorous ways of holding those with those powers to account. So there is that power concentration, a transfer of powers to the executive and to the agents of the state, including quite notably the police. That there is a risk when you pass emergency legislation that you abuse individual human rights. So often there is a balancing exercise to be done between the powers and duties and rights of the state to govern, the government to govern, and of individuals within society to have freedoms. And one of the dangers of emergency legislation is that it draws the line too much in favor of government policy and government objectives, and does not give due weight to the risk of abuse of individual human rights. That emergency legislation, again, as I've already mentioned, there is this risk that it suffers from a lack of proper, rigorous oversight of, say, Parliament. There is also the risk of what I've termed executive over-implementation. And that can be where, just to take the current pandemic as an example, the government has issued advice. Now, that advice is not legally binding. The government has also issued regulations. The regulations are legally binding. And there is this risk that, for example, in the powers given to police, they try and implement government advice as if it is law. And then you get this gap growing between the powers that the police believe they have based on government advice and the powers that they actually have based on the law. And policing in England and Wales is policing by consent. And if the police are seen to over-implement government advice as if it were law, then there is a risk that they lose the faith and trust of the communities which they're serving. And equally, it presents real big challenges, significant challenges to the concepts of the rule of law as understood in the UK constitutional settlements. So examples of emergency legislation, there are quite a few of them. The Civil Contingencies Act 2004, the Public Health Control of Diseases Act 1984, and most recently the Coronavirus Act 2020, which at the time of recording was a brand new Act of Parliament. So let's look at the 2020 pandemic and see how Parliament and the government reacted in terms of legislating for emergencies. So the global context that the coronavirus, COVID-19 as it's come to be known, was first identified in China at the end of 2019. It then slowly, but with an increasing ferocity and speed, spread throughout the rest of the world. So from January through to March, there was this creep and then this rush as the virus progressed around the world. Eventually, a pandemic was declared on the 11th of March by the World Health Organization, as a large number of countries were demonstrating community transmission, so transmission within the community, not just from cases of people who'd been to affected regions. If we then look more closely to home, the first reported case in the UK was in 2020. There was community transmission in February 2020, and by the end of March, the time this was recorded, there had been more than 20,000 confirmed infections and more than 2,000 deaths. And there was no sign of that at the time of recording, of that leveling off or plateauing. And so we would expect, very sadly, many, many more confirmed cases, and even more sadly, a greater number of deaths caused by COVID-19. And so you can see that a sense of emergency and urgency sort of emerge from that sort of context, where you have high levels of transmission of a highly infectious virus that can be deadly in those ranging from all ages, although it affects those in older age ranges more than younger ones. So how did the government begin? Well, the government began by using powers it already had. So it turned to the 1984 Act, the Public Health Control of Disease Act, to institute certain measures in an effort to control and flatten and bring down the peak of the infection to allow the NHS to cope. So that started with the closure of certain businesses, and that was done using delegated legislation under the Public Health Act 1984, that there was provision made for isolation of those who were infected with the virus, again, by way of regulation. And eventually restrictions on individual movement of citizens, even those who were not infected, other than where there was a reasonable excuse. So in essence, the regulations created a legal framework by which there were restrictions on your individual freedoms. So you had to have a reasonable excuse in order to leave your house, leave your residence. And some of those reasonable excuses were listed as examples. There was no sort of exhaustive list, but there were some examples, like going for essential groceries, food, for medical supplies, to go and visit and support someone who was vulnerable, for the purposes of exercise, to escape harm. All of those sorts of things were considered to be reasonable excuses. But what you see is you see the accruing of power to the government and them using that power in order to restrict individual freedoms. And for very many people, the argument is that that is perfectly legitimate and justified. I'm not taking a view or discussing a view on that here, just giving you the information. You need to understand the context. And then by March 2020, despite the fact that many of the powers necessary were already present in the Public Health Act, the government decided to propose a coronavirus bill that later passed to become the Coronavirus Act of 2020. And that gave the government more powers to act. And so we see that legislating in times of emergency, the government relied upon existing rules, existing powers to a certain degree, and then when it had the opportunity to reflect and think, proposed a bill with even greater powers. So, as I say, what you might want to think about is, why did the government need this new act if much of what it wanted to do could already be done by, amongst other pieces of legislation, the Public Health Act and the Civil Contingencies Act? And one of the reasons, one might suggest, is that the restrictions on the use of those acts, or the restrictions on the use of the powers within those acts, were quite strict. So certain things had 30-day limits and a need for constant renewal through Parliament and by Parliament. And there was an argument in the government's mind that this was inappropriate given the circumstances, and it needed much more sweeping powers with less opportunity for parliamentary oversight and less accountability. So let's have a look at this Coronavirus Act 2020 then. So the full text is available on legislation.gov.uk. You can see the link on the screen, or you can just go to legislation.gov.uk and type in Coronavirus Act, and the Act of Parliament will pop up. It is a fairly meaty act. It contains 102 sections and 29 schedules. This is not a minor, slim piece of legislation. Considering how quickly this act was drafted and passed, it is remarkable that it has 102 sections and 29 schedules. It made its passage through the entire parliamentary process in 4 sitting days. So this was a hugely expedited, rapidly passed piece of legislation. And one of the arguments about some of the stuff that it says, some of the problems in the drafting of it, are reflective of the fact that, one, it was drafted very quickly, and secondly, the sort of cycles of parliamentary thinking that would normally have gone into reviewing and amending the act were not possible. So some of the powers in the act that are given to the government happen automatically, and some require the passage of secondary legislation. So what is it that this emergency legislation is trying to do? The first thing is that it's trying to ease the burden on the NHS. And so it reduces existing duties on the NHS. The NHS, as a public authority with a very important and prominent public role, has lots and lots of duties on how it can act. The need for it within a certain amount of time to perform needs assessments, for example. The Coronavirus Act sweeps some of those duties away to free up capacity in the NHS and to prevent the NHS from becoming overwhelmed. But there are problems with that approach, and I hope you can think and see what those problems might be with releasing the NHS from some of its public duties. because it makes you wonder, why were those public duties there? Because they themselves, those public duties themselves, achieve important policy aims. That there were restrictive measures aimed at further slowing the spread of the virus, including regulating public gatherings, further restrictions on individuals, and the ability for the government to better control its borders. Some of these powers have yet to be used, but they're there just in case the current approach doesn't bring down the peak and flatten the peak of infection across the UK. So some of the other aspects of emergency legislation is just to allow business as usual to continue as best as possible. So, for example, the Coronavirus Act, amongst other things, loosens the requirement for in-person evidence to be given in certain forms of court proceeding. And this means that aspects of the justice system, whether that's the criminal justice system, the civil justice system, or the administrative justice system, it allows aspects of those systems to continue going in a time of crisis. And in some ways, emergency legislation, you can see the necessity of doing that to prevent the whole system from falling over or stopping. That there are certain very positive, depending on your political persuasion and whether you're a tenant or a landlord, but it protects tenants, residential tenants from eviction, and commercial tenants from forfeiture of their leases. So there's a certain aspect of protecting people that comes out of the Coronavirus Act 2020. It gives the power to postpone elections, local elections, and makes provision for the extension of terms of those who currently hold an elected office that was due to come to an end in the current crisis. That it would not seem sensible to have a period of canvassing, a period of door-to-door knocking, when actually you need a reasonable excuse in order to be able to leave your residence. So the Parent Act, sticking with the Coronavirus Act itself, there are some safeguards built in, baked into the Coronavirus Act, which is intended to deal with some of the criticisms I started this presentation with when considering emergency legislation. So some provisions actually actively require consultation with public health officials before they're enacted. So it can't just be a political decision to use powers under some of the powers under the Coronavirus Act. It actually has to be based on advice, on scientific and medical advice from public health officials. That the Act will stop having effect 2 years after passage. Now, that's a very, very long time. But the government felt that it required those powers, that it needed those powers to be extended to deal with the after effect of the coronavirus 2020. And so a very long lead out period has been given to the government in terms of these powers. But Parliament must debate the Act 1 year after it came into force. And so next March, we will see a debate on the Coronavirus Act 2020. And if the situation has fundamentally, radically, and irreversibly changed, then it may be that Parliament decides that it's time to bring to an end 1 year early the powers contained within the Coronavirus Act 2020. That ministers every 2 months must make a report available to Parliament on the use of the Act. So where it has used powers under the Coronavirus Act, the government will record those. The government will publish a report every 2 months, so that there will be some level of parliamentary scrutiny and indeed public scrutiny of the powers that are being used and the purpose to which those powers are being put. That for the powers, the transfer of powers, MPs, so Parliament will have the opportunity to vote every 6 months on whether it wishes to continue with some of the powers under the Act. So some can be switched on and switched off by MPs. And 6 months again is a fairly lengthy time in terms of parliamentary scrutiny. And then when it comes down to the secondary legislation passed under the Act, Parliament gets varying degree of control depending on the powers. So some things are essentially just reported to Parliament after the fact. Some things will require parliamentary input through the usual channels. That some of the provisions of the Coronavirus Act took effect immediately. So immediately on royal assent, they came into force. Some require action by ministers in order to come to force, and some powers can be switched off and switched on by ministers. So they can be commenced and they can be suspended as and when ministers need to make use of those powers. So let's have another little think about what does this mean. Think of the powers that have been given by the Coronavirus Act 2020 and think of the restriction on the use of those powers, and think then about how that plays into risk. What are the risks that I talked about earlier? Power concentration. Does the restriction on the use of the powers in the Act, the fact that Parliament gets a vote 1 year after, the publication of a report every 2 months, the fact that MPs can vote every 6 months on the continuation of the powers, does that do enough to mitigate the risk of a concentration of powers in the hands of government ministers and the agents of the state? There is this risk of abuse of individual human rights, whether that's right to property, whether that's right to liberty, however you want to characterize it. How does the powers in the Act, laid over with the restrictions on the use of those powers, play into this risk of abuse of individual human rights? Is there adequate oversight? Are there adequate levels of accountability present in this Act? Is this a worrying act in terms of the level of parliamentary oversight? And linking that back to discussions that are had in the book and elsewhere, does Parliament truly have powers of oversight when there is a majority government with such a strong majority as the current Conservative Party has at the time of recording? So even if Parliament does get to have a say, does the natural or inbuilt or default dominance of a majority party mean that even those restrictions on the use of powers are illusory? They're not actually real substantive oversight. What is the risk of executive over-implementation? And you can use a search engine to find the news stories about how the police have so far, or some police and some police forces have so far interpreted the regulations, the Parent Act, and government guidance, and whether there is evidence of over-implementation of the aims of the Act. And then stemming from that, you have examples of secondary legislation. So you had the Parent Act, either the Public Health Act or the Coronavirus Act. And what you can start to see now is how the government are using the emergency powers in order to try to get a grip on the situation. So you've got isolation of the infected. You can see the Health Protection Coronavirus Regulations 2020. It's a link on the screen if you want to note that down and follow it. You can read through precisely what the regulations say. For the closure of businesses, you can see the Health Protection Coronavirus Business Closure Regulations. And again, you can browse legislation.gov.uk to find the text of these regulations, and they might make an interesting case study for you to do so, to go away and look at what does emergency legislation actually look like when it's implemented. And then you have, as I mentioned before, the restrictions on individual movement other than where there is a reasonable excuse, and they can be found in the Health Protection Coronavirus Restrictions Regulations 2020. And I have a feeling that there will be very, very many more sets of regulations passed as the situation continues to unfold. And that's really all I wanted to discuss today, was to use a recent contemporary example of emergency legislation, the risks and dangers, its features, how it how it forms an important part of the legal system of England and Wales, whether that's through lawmaking, whether it's through understanding the institutions, whether it's through understanding primary law, whether it's understanding secondary law, or something that I'm sure will come in time when the court challenges come. And whether that's directly to particular regulations or whether it's challenging, say, the police or government's interpretation of the regulations through judicial reviews or contested criminal proceedings. As I say, I understand that this is a very difficult subject for some people, given that they will have been personally affected, as we all have been, by events in recent times. But the study of law, it's important that when we are able to, we confront those challenges and we look at how the legal system is responding to them. So thank you very much indeed for listening, and I shall see you again next time. Thank you and goodbye.